Ladies and gentlemen, a warm welcome to the inaugural Singapore Arbitration Dialogue. We're so pleased to have you join us here today in person and online. My name is Karen Tan, and I'm the Chief Strategy Officer at Maxwell Chambers. This dialogue is the first of what we hope will become an annual tradition, bringing together prominent and emerging arbitration practitioners to discuss issues that are relevant to our region. Our vision for the Singapore Arbitration Dialogue is kind of like a fireside chat, though given the warm Singapore climate, fireside chat might not be the appropriate word. Nevertheless, it is a space. It's a space for us to exchange ideas, learn from one another, and build connections within this region. We're therefore very proud to kick off this dialogue with such a distinguished set of speakers. Thank you again to Dato Justice Mary Lim, Justice Prakash, and May for making this possible. And of course, to you participants for taking time out of your busy schedule to be here with us this evening and in the morning and afternoon. Your presence here is a testament to the growing importance of arbitration in Asia and the wealth of expertise within our community. This event will be recorded, forming the start of a library dedicated to capturing the insights of prominent figures in Asian arbitration and sharing that knowledge with the global international arbitration community. A special thank you to the Singapore International Arbitration Center for their support in bringing this dialogue to life and co-organizing this first event with us. I would now like to hand over the proceedings to our MC for this evening, Ma Suen, who will introduce our esteemed guest speakers. Thank you.
Thank you, Karen. Good evening, everyone. A very warm welcome once again, and thank you for joining us today. My name is Ma Suen, SIAC's Senior Manager Legal Strategy and Development, and I'm pleased to be your MC. Without further ado, I would now like to invite our esteemed speakers today to join us on stage. Honorable Justice Dato Mary Lim, Honorable Justice Judith Prakash, and Ms. May Tai, the moderator for today's dialogue. Before I hand over the time to May, allow me to give a brief introduction of our esteemed speakers today. We are honored to have with us today Justice Dato Mary Lim and Justice Judith Prakash. Justice Dato Mary Lim formerly served as a judge of the Federal Court of Malaysia, which is the highest court in Malaysia. During her tenure as a federal court judge, the Malaysian judiciary saw the highest number of female judges ever appointed in the federal court. Justice Dato Mary Lim was also the first judge of the Construction Court in Kuala Lumpur. Justice Judith Prakash is a senior judge of the Supreme Court of Singapore. Justice Prakash was the first woman to be appointed a permanent judge of the Singapore Court of Appeal, and until 2022, she was the lead judge for arbitration matters. Justice Prakash was also a judge of the Dubai International Financial Center Courts, and she's on the SIAC panel of arbitrators. Last but not least, we have Ms. May Tai, our moderator for today. May is a consultant of Herbert Smith Freehills, and until last year, she was the managing partner of Herbert Smith Freehills' Asia offices. Listed as a leading individual by Chambers Asia Pacific and Asia Pacific Legal 500, May is a prominent arbitration practitioner, now mostly arbitrator, with extensive experience in particular expertise in cross-border, China-related, and Asian disputes. I will now hand the time over to May. May, please.
Thank you, Suen. So, what a delight and pleasure we have ahead of us to have you both captive answering my questions. Normally, the table is turned the other way, and you get to observe other people being grilled and cross-examined. But today, we are grilling these two senior judges. So to kick things off, you both have an aura about you. Singaporean and Malaysian lawyers and many further afields are in awe and a bit in fear of both of you, principally, but also because they principally the quality of the many judgments that you've written. And I think on your Wikipedia page, Justice Prakash, I read that you've written about 645 judgments.
Shows how old I am.
No,
I had a number of years to do that in,
No, it's your enormous work ethic. You are still 23 in our eyes. So many of us want to know, who is the person outside of the judge? Maybe we start with you, Dato Mary.
May, the fact that the front row is empty.
Yes.
What do you think?
It says a lot.
I don't think there is any difference between the two persona. What's the person outside the judge?
Yes.
I think very little, in my estimation. I think it's up to the public to go away, or perhaps to say there is actually any difference between the two personalities. I think how I view things are personified through my judgments. Those values live through my judgments. That's all I can say. And Judith, wouldn't you think so?
Of course, your values are personified in your judgments, but I try to run away a bit, and I wear pink nowadays. I was so tired of wearing black and white for 30 years, day in and day out. I try not to be so judgy when I'm not in court, but I fail very frequently. My husband and my children say, "You're not in court. Don't be judicious, react like a human being." So, well, it's a work in progress. I'm trying to achieve it.
Well, I can identify with that, Judith, because there's this little story. We were in Hong Kong recently, and because Justice Judith is like me, when we are in court, there are certain rules, there's an etiquette, and there are good reasons for it, isn't it? It's serious business when you're in court. And one of those things is don't drink, particularly with a water bottle and sticking it in face of the court. So here was Justice Judith in Hong Kong looking for a drink, and she asked for water, and the water came in a bottle, and she wouldn't touch it. I said, "Judith, what did you want?" She said, "I wanted water, but it's in a bottle." I've admonished a lawyer so many times, I can't get around to drinking it from a bottle myself. And I went and got a glass of water for her.
Which was really very kind of her. Yeah. Yes, I have been on occasion a bit abrupt with lawyers in my court who have picked up a bottle of water and just, poured it down their throats. Not quite proper, I think. But, well, that's only one thing I've scolded people about, as you all know. And I'm not going into it today, but I can see a number of you haven't worn ties. But those who have worn ties have worn nice ties, and I have nothing untoward to say about them.
It's a complete coincidence that I'm dressed in my most conservative suit. Just a coincidence. So both of you, your accomplishments run a mile long, and we really had to tell Sue Ann to keep it to a bare minimum, otherwise we'll still be at the introduction stage. But Justice Prakash, you were the first woman to be appointed as a permanent judge in the Court of Appeal, and Dato, you were the first, and I think still only, Chinese woman in the Malaysian equivalent, the highest court. So can you share with us some particular challenge that you faced along the way, any glass or bamboo or other ceiling that you encountered and you had to break through? And I should say that this is a question from one of the audience. Vanina submitted this question. Can we start with you, Justice Prakash?
It's rather hard for me to say that there was a bamboo ceiling. I think I was very lucky in that when I graduated, Singapore was growing, and there was such a great need for legal talent that it didn't matter so much whether you were male or female. Of course, I had the odd person, odd senior lawyer who would say to me, why don't you do conveyancing? Why do you want to go to court? Women look better in the office, but I didn't listen to all of that. And I was lucky that I had a pupil master who was our leading criminal lawyer at the time. And he didn't discriminate between men and women as far as his practice was concerned. And I had support from my friends, a lot of whom were male, and my husband, who was then my boyfriend, and none of them None of them discouraged me. And they said, you should do what you want to do. Mind you, having said that, and having been able to be a court lawyer for a number of years, when it was offered to me to change into solicitor's work, I accepted very gratefully. I think that I'm not as cut out for being an advocate as I thought I was. I wasn't a Perry Mason nor a David Marshall, far from it. But I was fortunate in meeting talented people who mentored me and didn't discriminate against me. So I don't have a story of a glass ceiling, really. Thank you.
I wasn't the first Chinese lady to be appointed as a judge. There were already 6. So they broke those ceilings, whatever kind they were for me. And I'm grateful for them having set those footprints for me to basically follow. But of the 6 or 7 of us who got upstairs, and when I say upstairs, it's for Malaysia, it's after the High Court, it's the Court of Appeal, and then the Federal Court. I was the only one thus far, and I don't like to think I'm the only one, and I'm sure there are many more to come, perhaps just a little bit delayed. But I was the first to go upstairs to the Federal Court. Why did I get there, or how did I get there? Age helped, I would think. The others had retired by the time they were elevated. I wasn't elevated any younger than the rest, but I think the background that I had perhaps made a difference. I was a litigator with the Attorney General's chambers. So I did a whole lot of court work, and I did a whole lot of arbitration as well. And that, I believe, prepared me for court work, though I never sat on the bench, unlike the 5 or 6 or 7 of them who went before me. And perhaps that then stood me out as far as the rest were concerned. And when they needed to, when the Chief Justice wanted to establish a construction court, he was looking for somebody with the appropriate experience, and I fitted the bill. Like Justice Judith, I stood on a lot of shoulders, and I'm ever grateful for them. And there were those many whom I owe a lot of gratitude, who didn't think there was anything wrong, but in fact, I think they enjoyed throwing me to the wolves. They enjoyed throwing this newbie and said, Mary, go to court. I remembered I was probably in my first 6 months in the Attorney General's chambers, and they sent me to appear for 10 judicial review cases before a High Court judge. And the whole bar turned up because they wanted to watch this newbie. And I think it's because I was tested and I was able to learn from those experiences that I finally, I think when time came, I was a choice, and I like to think a suitable choice for the Federal Court. But I like to think there are many, many more to come.
I'd like to add something, actually. Although in practice, I did not find any discrimination. When I first came out of law school, there were hardly any women who were serving as judges, even in the lower judiciary. And it was only when Justice Yong Pang Hao became Chief Justice and moved to revolutionize our legal proceedings and bring the courts up to speed and get rid of the backlog, that women became High Court judges and also were recruited for the state courts. He was a very open man as far as talent was concerned. And I think we owe women who are in the legal service and the judicial service actually owe the fact that they are recognized as good in these positions to his open-mindedness, because he threw open the doors and he recruited people whom he thought could do the job without regard to merit. I'm sorry, without regard to gender. I beg your pardon. I mean, I do think I had some merit.
Of course.
And I think as a result of that, you can see in this room, you know, there's a big mix of genders, diversity in age, and yes, you can see the fruits of what he started in the rest of the community. And just focusing now on your transition from being a judge to being an arbitrator, we in the arbitration community are obviously delighted that after such a long and successful and illustrious career as a judge, you've now turning your hand to sitting as arbitrator. And let's talk about that a little bit. First, and very important, I want to ask you about the powers of a judge versus arbiter. Judges obviously have powers, whereas arbitrators do not, when it comes to dealing with recalcitrant parties. So how does that change the process of the procedures and the decision-making for you, Prakash? Why don't you go first?
I think as far as the decision-making is concerned, it won't change, because I will make decisions the same way I've always made them. As far as the process is concerned, perhaps, and I find that I'm consulting the parties a bit more, letting them talk a bit more, not interrupting them so much. But I do think that I can't let, talking with people, sometimes parties can be a bit lackadaisical or recalcitrant. And it seems to me that you can't let this go too far, because it will be unfair to the other party who is involved in the arbitration. So I think that I will perhaps be a little bit more lenient, but I would still want to put down sort of guiding lines and hope that parties would abide by them. I'm not quite sure what I do when they wouldn't, but I'm sure there'll be ways that, it depends also on the other party, whether the other party wants to push along or not. But I don't think it is that arbitrators have no power. It's just that perhaps some people have been accommodating, and so some parties expect that, being too accommodating. Mary, you have a view on that too, right?
I'm a baby as far as arbitrators are concerned. All of you are just staring at me. Am I regretting the positions I took when I was a judge looking at arbitrators and their awards? Of course not. But I'm a little bit concerned about how it has evolved in the last 40 years. That perception about arbitrators having to listen to the parties, having to get mutuality of consent and views, and almost every step that is being contemplated requires parties' views and parties' consent and parties' will before you can ink it. I'm a little bit concerned about it, because I don't think that was how it was 40 years ago when I started arbitration. And the way I looked at arbitration in those days was the arbitrator was judge. It's supposed to be there to resolve disputes. Due process was due process. It didn't have the technicalities and the niceties, the fine arguments that public law has, that has somehow crept into arbitration. It's frightening. Because the arbitrators now seem to not be able to make any decision unless the parties say, hey, okay. What happened to arbitrators and arbitrators' powers? Because they're really the people who are there to resolve disputes. So like Justice Judith, how will I react if the parties, if I don't like their consent? Because I think it should be something else. I don't know. I'm just starting baby steps, but I am concerned about how arbitration has evolved in 40 years to be quite something that I didn't think it was. And I still don't think that's what arbitration is. Losing it out, being an alternative or a more appropriate mechanism for resolving disputes does not mean that that judge or that arbitrator, just call arbitrator, is a different creature. I still think there must be a wider measure of control, contrary to what seems to be out there at the moment. That's my view. And there goes those appointments, Judith.
I don't think that's true. I think there is a large population of counsel and parties who actually want an arbitrator that takes control more readily. I don't know. We were trying to figure out a word for such a person, whether it's decisive or authoritative arbitrator. So it's not in every case that parties, well, actually in most cases, parties don't want things to drag on because you're giving endless rounds of opportunities for comments and to reach consensus and all of that. But, you know, Justice Prakash, you've specialized in looking at challenges to arbitration awards for many years. So I don't think there's anyone more qualified to speak about the state of the natural justice challenges that we are facing today. I mean, do you have any views you can share on that?
Well, lawyers, and some of you lawyers here, have very creative arguments about natural justice and what is due process and how the arbitrator has to explain practically every step he or she has taken. And when I looked at those arguments, I was really taken aback, because I thought that if those arguments were accepted, then whole swathes of my decisions could be set aside, because I hadn't obeyed all those, little bits of things that had to be considered, had to be explained, had to be addressed. Yes, parties have a right to be heard, and they have a right to reasons, but really the way that lawyers sometimes put in arguments to try and upset what the arbitrator has decided goes much too far, because, well, maybe now that we have AI, the AI will be able to write an award that goes to 1,000 pages and covers every single point that was in issue, every single word that was said by the parties. But what you want, I believe, in an arbitrator, an arbitration tribunal, is common sense, knowledge of the law, commercial instincts, and good analysis of human behavior. You don't really need every little nitty-gritty to be dwelt upon in order to get a proper arbitration award. I mean, I understand that lawyers have to do this sometimes, but still, well, you know that I didn't accept such arguments when they came before me. And so it's not a secret for me to say that in the Singapore Supreme Court, these arguments are not very popular and well received.
In this room and outside this room, even with AI, they will still find some way to challenge it. Unfortunately, yes. There were some very interesting questions submitted by members of the audience that I wanted to turn to. One relates to the sort of judge-arbitrator dynamic. So one of them from Samuel Coe is, from the perspective of a long time serving senior judge, what can the arbitration community do to further elevate the standard of arbitral decision-making in the region? I mean, I think you have very unique insights into this. Look at an award and the process from the perspective of a judge after the event. So if you have some words of wisdom, we, the arbitration community, would be very grateful. Mary, did you want to tackle that one?
You know, when the question on breach of natural justice was asked of Justice Judith a while ago, I was recalling my own excursions into these areas, and horribly, they formed the longest of my judgments, because they were very painful and very detailed examination of those same principles. And it required you to go to so many jurisdictions. So in answer to your question, May, I would think that it would be the hallmark of not just a decent arbitrator, but an arbitrator who epitomize what an ideal arbitrator is one who keeps abreast with what's out there. It's not the length of your judgment. Fine, AI can do 1,000 pages, but I think the challenge to AI would write me a judgment in 10 pages, something like that, that contains all the succinct points. And to me, keeping abreast with the law is absolutely essential. Arbitration is not an excuse to get the law wrong and to get it different. There must, while it's about common sense, but it's also about certainty, and the principles don't change just because the mechanisms are different. It must be the same elucidation, the same application of those trite principles. And courts frequently say, if you've gone to Caesar, then you will have to leave by Caesar's justice. And I think recently one of the Malaysian Court of Appeal judges has said, well, you don't have to take Caesar's poison or something like that. But the point I want to make is that while the arbitrator has a lot of powers, there are so many more tools, and the fact that you can turn to the parties to assist you a lot more because of that autonomy. I think the awards ought not to be as long and painful as, 400 pages, 700 pages. They don't have to be that. And the principles ought to be the same. And it should be abreast with what's going on in any seat law. And that's my view.
No, not very much. I totally agree with Mary. Arbitrators and arbitration practitioners should keep abreast of what's going on. And I mean, now in the past, arbitration was a very different animal. You had experts who made the decision. You had lay people who were arguing, but it's become very judicialized now. And it's an alternative court process, really. And since the arbitrators are often lawyers and the parties are practically always represented by lawyers, I think the client should realize that the lawyers should give their clients the same level of service that they give them when they go to court. And therefore, I agree totally with what Mary has said. And the way to improve arbitration practice is to treat it in the same way that you would treat a case which was going to the Court of Appeal in Singapore, with utmost seriousness and with the knowledge of the law and doing the same amount of work, though perhaps not so much procedure.
Your answers actually reminds me, there is a allegedly famous saying that one of the ex-British prime ministers over the wartime said, I think he started his correspondence, one of his letters with, "I'm sorry for writing you such a long letter because I didn't have enough time to write you a short one." And I do think sometimes arbitrators fail to think through what are the key issues and how to streamline the issues, and so end up just writing everything that they think is relevant onto the piece of paper, which is not necessary.
But judges do that as well, not just the arbitrators.
Yes, we can all learn to be a bit more concise, I think. Another question, it's something we touched on earlier from Eric Wijaja. So for arbitrators who do not have the powers of judges to sanction parties, what advice would you give these arbitrators who face that difficulty? I think, Dato Mary, you mentioned earlier, there may be some tools in the toolkit to still assist arbitrators, even though they don't have the same coercive powers as judges.
Well, I thought, Judith, you were saying you were not sure how you would react if they didn't. I'm not sure how I would react. Probably keep that ace up my sleeve for a bit.
Yes, the element of surprise is very
Yes.
important.
Yes, anticipation.
Okay, we shall have to appear before the two of them as arbitrators to find out.
Yes, but I'm sure that everyone in this room will not put us in this awkward position of having to enforce anything.
Yes. So sort of moving away then from the topic of judge versus arbitrator, I think there's a lot of us in the room who'd actually really appreciate your wisdom and guidance on other topics as well. So as you notice, there's a lot of younger generation arbitration lawyers in the room. So for those who are early in their career and who want to have a shot at having a career as long and illustrious as yours, what would you tell them to do more of or less of in these early years? Dato Mary.
Well, I think, you know, what I really admire about the young today is the courage that they have. And I think AI has helped that. Unlike my time, where in order to change, in order to try something, I had to leave the room, I had to leave country, I had to leave home. A lot of you don't have to do that. You can still do a lot of different things from that little handphone of yours, change employers if you don't like it. And I cannot use my values to say that's wrong. This is your time. And I think you should continue in that path. And it is up to people like Justice Judith and I, and you, May, you're such illustrious career. A lot of you may not realize May's just been appointed one of the vice presidents. Am I allowed to say this in Maxwell Chambers, that she's been appointed vice president of ICC? You know, huge congratulations to her. And she's Malaysian. I'm so totally proud of her. So as far as the young concerned, just keep doing what you're doing. And the seniors in the room, I think you need, and seniors out there, look, you need to share that space with them. You need to give them that few moments. It's all right. It doesn't diminish us. In fact, they do a lot of wonders for us and for our prestige, you know, that, oh, this is a mini Justice Judith or something like that, if it's even possible. The point is, we owe it to the young to just give a little a hand up. We heard a while ago, Justice Judith saying that a lot is due to those men or women, it so happened to be men, who had that foresight, that courage to give us a hand. And I think we should continue doing that.
Yes, I couldn't agree more that those of us who have got to certain positions should be helping the younger ones. And as far as the younger ones are concerned, of course, the usual advice is that they should work hard, focus, not be too, you know, not run away from faddish and run away from one thing to the other, because you have to achieve a reputation in a certain area if you want to move up, whether as a litigator or an arbitrator. But I would also say to them that they shouldn't forget there are other things in life apart from arbitration and apart from the law. Yes. And they should try and, I know it's very hard. I mean, I'm very, very grateful that when I was a lawyer, when I first started out, a letter would come in, I would dictate a reply, my secretary would type it out, and it would go off, and I wouldn't get a response till 2 days later. And then subsequently, the fax machine came into effect, and that made me speed up a bit more. But I never got to the stage where my clients and my bosses were pursuing me 24 hours a day. And that is what the young people have to deal with nowadays. And I think it is, it it cuts too much into your life if you're working 24 hours, because you need time to refresh, you need time to keep your human relationships going, and you need time to get other interests and do other things. Law is not the be-all and the end-all. That is something my husband said to me many years ago. And he's been very good at making sure I didn't go overboard and kept within limits. So to the older ones as well, please give space to the younger ones to develop themselves and their relationships and their families.
May, would I be wrong if the seniors will probably be upset with what I'm
senior.
No. I'm just sharing with you that the seniors in the room may be upset with what I'm going to suggest. It's all right to stop doing law or have anything to do with law. Just walk away. It's all right. That's what I wanted to say. It's not while you may have another life, it's all right to tell law, I've had enough. I want to do something else. That's the point I want to make, because something I didn't say is I'm very, very concerned about suicide. And it's had stress, and law has had a lot of impact on our young ones and on the senior ones. And it is all right to say, I've had enough. I want to do something. As somebody asked me a while ago before we started, how has it been like, Judge? And I said, what? Retirement? I said, I have yet to find out. I'm still waiting for the moment where I can be on the beach and with a pina colada. So I'm still waiting for that moment.
Don't worry, I'm coaching her on that. As you all know, I left partnership, as some of you just heard, and being a managing partner in order to have a better work-life balance. So yes, no, I completely agree. You need to find something outside the law. And on the senior, sorry, I'm supposed to be interviewing them, but I did want to add on the senior junior tip. You made me think of something that I learned when I was an associate. It's very important for those of you who are senior to have a transparent calendar or work calendar. And it's very important for those of you who are junior to make sure you snoop your boss's calendar, because that's when you're going to find gaps. When they're at the gym, when they're out to dinner with clients, they're clearly not going to be chasing you for things, and you should have a break as well. I used to love it when my bosses took transatlantic, trans-Pacific flights, because it was like 18 hours of freedom. Sadly, these days, most planes have Wi-Fi, so that avenue is out. And then we have a question from Wendy Lim, who wanted to know, with all your decades of experience on the bench, you've seen clearly some really excellent advocacy and some mediocre advocacy. Sorry. Can you share some of the do's and some of the do-nots with us?
I think this comes down really to hard work and preparation, and having enough detachment to figure out what are the bad points in your case. Try not to put them forward at all. And if you do put them forward and you're challenged on them, move away, instead of pounding on, feeling that your client is sitting behind you and will get angry with you if you don't make the point. Because all you do when you pound on your bad points is irritate the judge, maybe the arbitrator, I don't know yet. And they'll forget I would forget perhaps your good points in the to and froing of trying to show you why your bad points are bad points. So the don't really is concentrate on the good and try and divert the attention from the bad to the good. Push your strongest points. Thank you.
I will make 3 points here. And that's what a good advocate should do. Know exactly how many points, and the fewer the better. The first point is good advocates are not necessarily the senior ones. I saw one of the best examples of advocacy from a young lady stood up completely unassisted, took her iPad and took us through her submissions, managing the mic, managing the documents, managing the submissions. So it's not the domain or the exclusive domain of seniors. It just comes with the preparation that Justice Judith has talked about. The second point I want to make is this: the amount of trust I have in counsel. I am very, very old school. When a lawyer stands up, I actually believe that lawyer. And it's the amount of trust I have in that person. And that lawyer says, because it's the best case, the best arguments, I believe in that argument. And then I'm supposed to be able to incorporate that into my judgment. And so I can't say it enough, and I wish the lawyers had listened. I really believe them, whether I truly believed in it and finally it rules the final decision is something else. The point is how much trust the judges, I as a judge had in counsel cannot be said enough. The third is that the integrity. Because of that trust, because I believe, counsel then really should be doing the best argument and don't waste their time. So how do you do that? I'm a huge fan and believer of advocacy training. And that's something I've been doing for a long, long time. And that advocacy training doesn't stop whether you're doing arbitration or you're doing litigation. You should continue to go out there and train either as a trainer or be a trainee. Nothing beats going back on the beat, even in the academia, to just check whether you're doing the best arguments.
Now, going back to that theme of there's more to life than the law, your work has obviously been very important for society and very impressive. You work very hard and you perform at the highest levels. Now, how do your family handle the stress of living with you in those circumstances?
Jay is here to make sure she's performing.
Let's see what she has to say and then whether you agree.
Well, my family get tired of being asked by friends and people they meet, particularly lawyers, how do you live with her? She's so fierce. And they say to them, or at least they tell me, they say to them, she's just an ordinary mother, you know? I mean, she's very naggy, but how many mothers are not naggy? And I think immediately you become a mother, you become a nag. I always thought I was very patient and I never nag, but that has changed over the years. Well, my family known me. I think they know what I'm like. They know how to manage me, and I don't think it's that hard for them to live with me. Well, but I leave it open to you to ask around, those nearest and dearest what they think.
When I retired, I had this wonderful opportunity of saying thank you to society in Malaysia for giving me that opportunity to serve the nation for 43 years. And in my thank you, I thank my family for putting up with me and allowing me that space. It really was because of them giving me that space, that support. Particularly my husband, my daughters. My husband was the one who made sure the house was quiet so that I could get on with writing judgments. It didn't help because, I wish you said, Mary, why don't you go and sleep? But instead, I think I'll keep them, everybody quiet. You can write. Do you want me to get you a cup of tea? And the mates didn't help as well. So everybody was making sure I was getting on with the work. I think there was a plot out there. So family support, stressful on them, but they never asked about work. But if I couldn't have taken, and I couldn't have taken the step, I couldn't have stayed so long, but for their support. My daughter, like Justice Judith, was asked in fact, asked somebody whether some interns, whether they would like to intern with me. And those interns actually said, "Oh, do you know Justice Mary?" "I do, she's my mother." "She's your mother?" And it's like, I can't have children. And of course the question was, she like at home? And the same like all mothers. And they're surprised that we're actually capable of being mothers, wives, sisters. Although I'm not sure whether any one of you have had that experience. "Mom, you're not in court. Let go, please."
That happened to me a lot.
And that's in a restaurant, okay? If I get bad service, I would be, I would say a few things. And I get those remarks. "Mom, you're not in court. Let go."
Don't cross-examine me. I went out, I came home. You don't have to know every detail of what I was doing. But like Mary, I was fortunate. My husband supported me. My children supported me. They encouraged me to do all these things. And one of my daughters actually said to me, "At one time I thought you should be at home and you shouldn't go out to work. But when I thought about it a bit more, I realized that I had so much more freedom when you weren't around." So
There are the pros and cons of having a judge as your mother. So I wanted to flip back to diversity, which is something we touched on a bit earlier. I mean, you have, despite, giving credit to a lot of people, you have both risen to the top of a very difficult profession at a time when there was not so much emphasis on diversity as there is today. And today, although there is some emphasis on diversity, there's also some backlash against diversity, because some people think that one may be prioritizing diversity over merit. And Dato Mary, I know you think about this a lot, so keen to hear your thoughts about all of this.
Diversity at the bench or diversity in practice?
Both, but probably at the bench, because that's sort of most relevant to your experience.
I think you must, and I'm speaking totally as a Malaysian, you must have diversity. Commercial disputes, perhaps less of a requirement. It's pretty cut and dry. But as far as other matters that confront the courts, we have a huge variety of work. The diversity and the problems, they're all due to local conditions. And therefore, that diversity is critical. And unless, of course, one could say that the panel of all male of any race is capable of understanding all the nuances of the different communities in Malaysia. And the answer is actually no. We may think we know, but really we don't. And for Malaysia, particularly East Malaysia, it's become quite an issue that the East Malaysians do want to have a judge from the two states, from either of the two states, so that they could understand local conditions, particularly for their land matters, because the law is quite different and it deals with community issues, which the judges who do not have that experience or who are not from that area probably may not be able to appreciate it fully. So for me, diversity, and thankfully, we've got judges who are from so many of our minor communities. We've had, of course, Stone Richard is of a mixed Kadazan and various races and various tribes. So we've got a Kalabit judge. We've got so many of our minority tribes. So pretty proud of that. But I think they have brought to the panel arguments, particularly in the ante room, the nuances that we may not have been able to appreciate, and sometimes counsel may not be able to communicate to the bench. So I think diversity is important, particularly since education has reached all quarters, they must be given a chance. But diversity for the sake of diversity alone, no, there must be merit. Always merit is important.
And anything to add in terms of your experience of the arbitration community and what's happening in arbitration on the diversity question?
I'm watching that space. I don't know how much of it is good, particularly for Asian now. Now let's look at the larger ecosystem. Let's look at Asia. I think there is a shift, and it's a very positive shift. I'm still watching the space.
Justice Prakash.
Well, Singapore is yes, we say we're multicultural and we're multiracial and we're multilingual. Yes, we are all of those, but we're actually very much more homogenous than Malaysia is, because we have a national education system. Everybody learns English and also learns their mother tongue, and we inculcate national values. So as far as diversity is concerned in Singapore, I think we have done quite well in promoting diversity of gender and diversity of racial, of ethnic communities within the legal field, within the judicial field. So, but we have actually done it mainly on merit. And I don't think that we put aside merit when we consider these things, but we do also, I mean, we don't choose somebody because they're of a particular race, but we're lucky enough to have a whole lot of meritorious people who come from various backgrounds. In the arbitration community, I don't know that much about it, but except that it used to be so Europe-centric. And now, over the past 30 years since the SIAC, well, the Singapore International Arbitration Act came into force and the SIAC was established, it has become here and in Hong Kong as well, so much more Asian focused. And, you know, when I was a young lawyer, and even when I started on the bench, there was hardly an international, well, there wasn't an international arbitration. Most arbitrations were construction arbitrations, and there were certain lawyers and judges and arbitrators who specialized in them. But the push that we have made since the establishment of the SIAC has been tremendous. And I think that we have contributed to providing diverse arbitrators available for communities in Asia. And I think that the SIAC and the HKIAC have both done excellent jobs in that regard. So, and I'm all in favor, of course, in providing parties who need to arbitrate with a selection of arbitrators so that they can find someone whom they think will be able to at least will understand their perspective, may not agree with them on the points, but will understand their perspective.
So actually, I think what we have made now, following from what Justice Judith said, is that the pool of available diverse arbitrators is getting larger and deeper, and I think that's positive. So but as I said earlier, I'm watching the space. I don't think it's nominal. There must be. We must sustain this growth. This is what we need to do.
Now, I've still got lots and lots of questions, but I must give the audience an opportunity to ask questions as well. So maybe we start with people in the room. I've got a couple online. Do they need a mic, Karen, or is it okay? Right, someone's going to get you a mic. Maybe introduce yourself as well.
Hi, my name is Sin Yi from Sharp and Jagger. I think I just wanted to ask the question, which is what is your take on career arbitrators? I know that throughout your career, you started as a judge, and then after that you move into arbitration. But nowadays we are seeing people who become career arbitrators, and when they are career arbitrators, then it becomes very important that you sort of, if I were to use very colloquial language, you cannot piss off anybody, because if you do that, you may not get the next appointment. And to your point previously, when you said, I think it was Dato Mary who said you're not quite sure the state of arbitration and how they allow recalcitrant parties to just get on and on with their ways. Is it because is it because we now have career arbitrators who have got to make sure that they get their next appointment, and that's why it seems to be getting out of hand?
I think that's a rather difficult question for both of us to answer, because we're just dipping our toes in this world. Of course, I mean, you can say that there would be people who would tend to bow a bit, but I don't think, generally speaking, that is what people in the arbitration community do, especially in places like Singapore and Hong Kong, where you have strong arbitration centers which are promoting arbitration, are promoting the ethics, and promoting the behavior of arbitrators. I assume that anybody who is able to take on a job as a change from being a lawyer to a commercial arbitrator or a career arbitrator would have had quite a lot of experience in the commercial field and would have built up a reputation. And, Dato Mary said that respect is very important. And one thing that arbitrators depend on, really, is the respect of the lawyers. You don't get an appointment if a lawyer does not respect you. And it may be you have there's one party nominates you, the other party, if that party thinks you're the wavering sort who might be, might give way, will object. So there are some checks and balances. And I think that if you really want to, if you can start out as a career arbitrator or saying this is going to be my career and then bend with the wind, I think that will be a rather short career.
When I highlighted that problem, it was bringing to the audience my awareness of this issue that is out there. I think it's something that we need to talk aloud about. But thankfully, and this would be a disservice if I didn't say this about career arbitrators, who are, and the majority of them really are, the ones made of good stuff, who, one of them actually said to me, I just wish, and this is how I control the proceedings, they really move things along. And these are coming from the career arbitrators. But I had highlighted that because I don't want that to become something that's insidious and then it becomes pervasive. It needs to be recognized, it needs to be checked, but it will be a disservice and it will be wrong of me to not acknowledge so many good arbitrators, career arbitrators out there who are doing so much right and closing arbitrations well within and ahead of time. So I'm sorry if I've given the wrong impression, as if arbitrators are doing bad work out there. Apologize about that.
Do we have another question from the audience? If not, do we have time for one more from online? So we have one from Cindy Wong, who wants to know, given your retirement and your semi-retirement, what continues to fuel your passion? They've both taken back their retirement, so they don't have an answer to the question.
I just think that I like solving problems and dealing with with puzzles. Well, that's the way my brain works. It's a practical brain. It's not one of these creative brains. And so I'm used to doing this sort of thing, and I enjoy it. And if I didn't do it, well, I'd probably become a couch potato, which is not very good for me in the long run.
I can't believe we would do.
This brings to mind, must correct the introduction just now. I'm still retired, dabbing my toes, as Judith said a while ago, into arbitration. I'm only pro tem chairperson, so I'm not president of the Court of Arbitration in the AIAC Malaysia, not at all. I, like Judith, I actually love reasoning. I love solving the problem, and I love reasoning it out and writing it out. And I tell you, I derive such immense pleasure getting to the end of the road. It may not have satisfied everybody, but by the time I got these kind of exercises or judgments written at the appellate court, at the apex court, it was such a huge privilege, and I really enjoyed those journeys of reasoning, resolving the principles, and pushing the envelope and trying to find solutions that could take society to a better place. I really love those puzzles.
Well, and long may you continue solving puzzles for us. I think we've run out of time. So all that remains, I think, is for me to give a huge thanks to the two judges for sharing their wisdom, their process, their thinking, the future of arbitration with us. And hopefully we will hear more from you in the coming months and years. Please join me in giving them.
Thank you, May.
And I'll pass back to Sue-Ann.
Thank you. Thank you to our esteemed speakers today. Ladies and gentlemen, that concludes the event this evening. Thank you once again for joining us in person and also online. We hope to see you again soon. Thank you.